Hello everyone, and thanks for joining us. Today, we're going to talk about asylum. When and how you file affirmative first defensive application. Even though the current administration has reduced the number of asylees allowed in the U.S. every year since 2016, it is still a valid way to obtain your green card. In fiscal year 2019, USCIS found that 72,252 applicants met the credible fear standard in their application process. You've probably heard my story, but if you haven't, I want to share it with you. My name is Andres Mejer. I'm an immigration attorney. My family immigrated to the U.S. when I was a child. We came here with visas and we hired an attorney. 2 years later and $5,000 later, they did absolutely nothing for us. They said they were going to help us get their green cards and they did nothing. We lived without legal status for almost a decade. I decided to become a U.S. citizen and an attorney to help people like my family. I'm committed to helping 5,000 families in the next 5 years get legal status. My office does everything it can for the clients we have the privilege of serving as if we're helping our own family members. I consider each of my clients to be part of my family, which is huge now because we've helped almost 4,000 people pursue their dream of legal status. In order to qualify for asylum, you have to file within 1 year of your last entry to the U.S. If you entered legally, you just show your passport. This is called an affirmative application and it is filed with USCIS. However, if you entered without inspection, it becomes harder to prove when you enter the United States. If you have maintained a legal visa the entire time of your stay, you're not limited to the 1 year deadline, but you must apply within 1 year of when that status expired. So tourist visa, H-1B visa, student visa. So imagine you come here from China, you enter as a student, you study, you file H-1B, your H-1B lapses, you have 1 year from when it lapsed. Even though you've been here 8 years, you still have one more because your status just expired. If you missed the 1 year deadline, there is an exception for changed circumstances in your personal life or in conditions in the U.S. or your home country that was material to your eligibility for asylum and that you filed within a reasonable time after the circumstances happened or you learned about it. So, you missed the 1 year deadline, you got to show what are the changed circumstances that caused you to miss it, and did you file within a reasonable time after that condition ended? You were not, so for example, you were not afraid to return home when you entered the U.S., but you are afraid now because people like you are now being persecuted. So think of new government who's now against your political party. You were not in danger 5 years ago when you left Chile, but now because of the changed government, now you are in danger if you go back. You became active in political or religious activities in your home country after leaving your home country, which now puts you in risk of persecution. So, for example, you are from Iran and you married a Christian woman and you converted to Christianity. You go back to Iran now, they might kill you. You're divorced and your spouse was the primary applicant, so you now need to apply on your own. If you missed a 1 year deadline, there is another exception if you experienced extraordinary circumstances material to your eligibility for asylum, and again, you filed within a reasonable time after the changed circumstances occurred. That means events in your life before or after your arrival to the U.S. relate to your timely filing, and you filed within a reasonable time after the extraordinary circumstances stopped affecting you. You need to show that you didn't create the extraordinary circumstances through your action or inaction, meaning your failure to act. Let me give you some examples. You suffered a serious psychiatric or medical illness during at least part of the 1 year period. Think COVID-19. For this example, you would probably have to show that you personally contracted COVID-19. That would likely work. If it's a family member, well, it may or may not. It depends on what the situation was. You were legally disabled during the period. Third option, ineffective assistance of your lawyer or notario or a scam artist, which directly related to the delay in filing. You need to act quickly after failing to file on time. You have to document what happened. You have to prove you saw this person, explain your reasons for trusting this person, including cultural or language reasons why you thought the person was an attorney, and explain what this person did or did not do. You will be called for an interview with an asylum officer who will ask you a series of questions. At the end of the interview, the officer will make a decision on your application. That decision is often not the same day as the interview. If you are approved, you will be granted refugee status, and 1 year later, you can file for your lawful permanent resident using Form I-45. In other words, you can file for your green card. If you are denied by USCIS, you will be placed in removal proceedings. While this may be scary for you, being put in removal proceedings gives you a second opportunity to apply for asylum. A defensive asylum application is filed when you are in removal proceedings. So if you applied for asylum affirmatively, you were denied, then put into removal, you are now filing defensively. This can happen if you are in the U.S. and put into removal proceedings, or if you are caught at the border and put into removal proceedings when you tried to enter the U.S. Either way, you still have to apply within 1 year of your last entry to the U.S. unless you have a valid exception. Sometimes I have people who come to me because they have been in the U.S. 10 years and another attorney or a notario told them they could file for asylum. This is not true. When the asylum is denied, you will be put into removal proceedings. This is a method to then apply for cancellation or removal for non-lawful permanent residents. You should renew so in that circumstance, you don't withdraw your asylum is denied, you get put into removal, you should renew your asylum application, and then you can also argue that the law should protect you. So what we're saying here is, you've been in the country 10 years. You're saying, hey, listen, I'm afraid to go back because of this reason. And you're saying the law should protect me, even though maybe today it doesn't. You can still make the argument that it should. And in addition to that, you can make the separate argument that you should be entitled to cancellation or removal for non-green card holders. Now, we've made a video that discusses cancellation removals in its 3 forms. See the comments below for a link to that video. Your asylum application is filed with an immigration judge at EOIR, the Executive Office for Immigration Review, instead of through USCIS. You must have your own attorney when you are in front of EOIR, as one will not be appointed for you. You will likely have several court appearances before your final trial date. At the trial date, the immigration judge will either approve your case or deny it. If the judge denies your case, you can either accept that decision or you appeal it to the Board of Immigration Appeals. This is a difficult time for every immigrant to the U.S. It seems like this administration is making it harder and harder for those seeking for asylum. If you think you may qualify, please contact our office. We will work with you. If you don't qualify, we can help you determine your next best steps, including looking at the possibility of other legal status. We have often found relief for our clients when other attorneys said there was no hope. So what is asylum? Asylum is a protection that is given to someone leaving their home country due to safety concerns. Put another way, it's a legal status that is applied for by a person who is fleeing persecution in their home country. The United Nations Refugee Act requires the U.S. to grant asylum to people who meet the criteria. Asylees are people who apply for asylum. While asylees are refugees from their own country, the term refugee in U.S. immigration is used to refer to those who are applying for asylum from outside the United States. Inside the United States, the U.S. calls it asylum. So asylum and asylees are the terms used for those who are applying inside the U.S. and compared to refugees that are applied usually with other non-governmental entities who are assisting in the refugee process. In order to qualify for asylum, you must prove that you have a credible fear of persecution in your home country because of a protected reason. Let's break that down because it's complicated. First, persecution. You have a credible fear of persecution if you return to your country. That is more than just fear that you'll be subject to torture, imprisonment, or physical abuse. So either something bad happened to you, or you have a really good reason to suspect something bad will happen when you return. Supreme Court of the U.S. has said that there only needs to be a 10% chance that bad things will happen to you in order for you to meet the threshold necessary for asylum. Proof. You must show that the persecution is caused by the government of your home country or by a group your home country the government is unable or unwilling to control. And it has to be for a protected reason. So you have to be persecuted. What does that mean? That you'll be tortured, imprisoned, or you will get physical abuse. By whom? By the government or someone the government can't or won't control. And three, why is this happening? It has to be for a protected reason. Persecution can't be just for any reason. It has to be for one of 5 reasons protected by law. First, race or nationality. It's actually 2. I group race and nationality together because the distinction is often not clear. Race, nationality, I'll even throw in ethnicity, are often blurred and frequently misused. Take a Native American or an American of African descent. Now, that could be ethnicity, that could be race. It could even be nationality. So it does get confusing. Take an Italian American, that's definitely a nationality, but it could also be an ethnic group. Think language, culture, food. Ethnic groups further blur these lines. An ethnic group usually shares cultural history or linguistic history. It can also be a shared political history, but doesn't have to be. Think of the Kurds. They're in Syria, Turkey, and Iraq. Now they want their own country. They have similar political history, they have similar cultural and linguistic history, but obviously their political situation in Syria might be different than Turkey and in Iraq. Certainly it's different than Iraq, which is almost an autonomous area. An ethnic group can also have racial categories, which are usually based on physical characteristics. Think of indigenous features of, for example, the Mapuche in Chile, where I was born, or the Mayans in Mexico. Second, so we got race, nationality. Third, religion. This doesn't have to be a difference in religion, like think Christians or Coptics who are in Egypt, a Muslim country. But it does have to be persecution due to religion. So if you are targeted by a gang in El Salvador because you work for a church to help drug abusers beat their addiction, that is still persecution on account of religion. 4. Political opinion. This refers to attitudes that people have regarding their country, government, or society. The attitudes can be expressed by voting, party membership, union membership, advocating, or just commenting on public affairs. Public opinion can also be imputed, rightly or wrongly, from people's behavior or from who people associate with. Let me give you an example. An employer can be persecuted for employing a political activist, even if this job has nothing to do with politics and the employer didn't even know about his activism. So in that case, the employer's political opinion is imputed because of who he employs. It doesn't mean it actually is his political opinion. It just means he's perceived to have that opinion. Another example is someone who's targeted as a homosexual because he has a gay friend. That is, again, an imputed political opinion. The assumption is just because someone he knows is gay, he must be gay too. Now, that political opinion, specifically homosexuality, can also be a particular social group, which is the next protected ground. 5. Particular social group is a group sharing a common characteristic that is so fundamental to their individual identity that they cannot or should not be expected to change it. It is people who have a similar background, social status, lineage, experience, or habits. Shared characteristics could be something you were born with, like gender, color, or family ties. It can also be a shared experience, like property owner, former gang member, former military official, or police officer. Example of particular social groups that have been approved by law, tribes, well, by law I really mean by case decisions, and appeals. Tribes, ethnic groups, which we previously discussed. Social classes, for example, educated elites. Now, we don't want to say rich or poor. That's very hard to define, but we'll discuss that later in a little bit. Family members of dissidents, homosexuals, child soldiers, former members of police or military targeted for assassination. The U.S. had been recognizing persecution based on gender. For example, being forced to or afraid that you will be forced to undergo female genital mutilation, Islamic dress code requirements, forced marriage, or domestic violence. Now, I've previously talked about domestic violence because in 2018, Attorney General Jeff Sessions challenged whether domestic violence can be a particular social group. I explained then, and I still argue today, that women who don't want to be abused or are considered property, that sentiment is also an expression of a political opinion, which is a separate protected ground. So, female afraid of domestic violence alone as only a particular social group would be a mistake. It should be particular social group and political opinion. That just means you got to check the right box when you fill out the form, which is why it's important to have the right attorney when you do this. A group is more likely to be a particular social group if it is unique in society. Take, for example, rich or poor. Since those terms can't easily be defined, it would be hard to prove what does rich mean? What does poor mean? How much is it? How much money they make? Is it the house they live? Is it the place where they live? Is it the schools their kids go? Is it the cars they drive? What is the definition? It's too vague. So compare that with women who are rape victims of militants in their home countries. That is clear, it is precise, and it is a lot easier to define. How to apply. You must file Form I-589, Application for Asylum and Withholding of Removal, within 1 year of your arrival to the U.S. There is no fee to apply for asylum today, but the government is trying to change that. You should include your spouse and children, by children I mean under 21 and not married, who are in the U.S. with you when you file the application. Or you can amend your application up until the time you make a final decision, or a final decision is made on your application. After you file, you can check your case status with the receipt number that will be mailed to you at uscis.gov/case status. This is a difficult time for every immigrant to the U.S. It seems like this administration is making it harder and harder for those seeking for asylum. If you think you may qualify, please contact our office. We will work with you. If you don't qualify, we can help you determine your next best steps, including looking at the possibility of other legal status. We have often found relief for our clients when other attorneys said there was no hope. How much will your asylum cost and how long will it take? It's the question everybody asks. As of today, August 24th, 2020, there is no fee to file Form I-589 for asylum, withholding, removal, or CAT relief. That is changing October 2nd, 2020. Also, if you apply after today, you must use the new Form I-589 that you can find on the USCIS website. Make sure you use the properly dated form or your application will be rejected and your date of receipt will not start until USCIS receives the correct application, which could put you outside the 1-year time limit. The rule for asylum seekers to obtain an EAD card, employment authorization, also has changed. It goes into effect tomorrow, August 25th. It is very important that you understand how this law will impact you and your stay in the United States. If you need help understanding this for your particular situation, we recommend you consult with an immigration attorney. We can only provide general advice in these videos. The biggest change is that asylum seekers cannot apply for work authorization until 365 days after their asylum application is received by USCIS. It's gone from 150 days to a whole year. There is also the chance you will be denied an employment card if you have illegal entry or certain criminal convictions under the new rule. I do suspect that there will be challenges to this rule, but for now it's still going into effect. When we evaluate your case, we start with 3 questions and we create a plan for you before we accept you as a client. We only take on clients we can help. 1. Do you qualify for a green card through asylum? 2. Is there something in your past that can disqualify you, like multiple entries, prior denied petitions, criminal charges, removal proceedings? And 3. Can we fix that problem through a motion to reopen, post-conviction relief, or a waiver? Because we focus on those 3 questions, 2 clients who both are filing for asylum might have very different costs. In general, here's how we charge fees whether you are filing for asylum or for your green card through asylum. We first review your background. We typically charge $1,000 per person to do the following. 1. Order through a 4-year process all your immigration documents from 7 different agencies. We're looking for prior border contacts, any deportations, or any prior petitions. Secondly, do we need to order copies of your criminal or juvenile courts and do a background search from the FBI? Basically, if you've ever been arrested, we want to find out who it's from, what happened, get those dispositions. If there is something that makes you ineligible, once we get the results from immigration and we get the results from the FBI and from the courts, we then say, okay, there's something that makes you ineligible. Now we look at how can we fix it. And maybe it's a waiver, or maybe it's reopening a criminal case, maybe it's reopening a removal order or refiling for relief. Post-conviction relief motions are the most common, and those costs really vary from $3,000 to $15,000. It depends on the severity of the charges that you face. Once you file Form I-589, you may have a hearing before an asylum officer on an affirmative asylum claim. You don't get this option if you are in removal proceedings. We strongly encourage you to bring an attorney with you because if you are denied, you will be placed into removal proceedings. We typically charge between $4,000 to $5,000 to attend the hearing with you. We treat it like a trial. If you are in removal proceedings, then we charge you $1,500 to go with you to each court appearance in New York, New Jersey, or Philadelphia. If you have multiple family members who have court on the same day before the same judge, we only charge one fee. If you are in removal proceedings, you will ultimately have a trial before the judge on your Form I-589 claim. We typically charge between $5,000 and $6,000 depending on the complexity of the issues we're handling for you. Once your asylum is approved, after 1 year, you'll be able to file for your green card through Form I-485. We typically charge between $4,000 to $5,000 to file for your green card. You may also have an interview with the USCIS officer. You shouldn't have to, but under the Trump administration, it's become common, and we charge $1,500 to go with you to an interview in New Jersey, New York, or Philly. Whether it's a jail visit, whether it's a court appearance, or whether it's an appearance at an administrative agency, it's all about half a day's work, and that's why we charge the same price, $1,500 for all 3. As you can see, each one of these has a cost. It's for that reason that my assistants can't give you a price on the phone. It requires the knowledge and experience to figure out the answers to 1, 2, and 3, and then put a price to it. However, we do offer a variety of discounts and ways to pay your legal fees. If you pay in full, we give you a discount. We also give discounts for repeat customers. So if we help you with all 3 steps, or if we help you with prior applications, we give you an additional discount. The more money you bring with you to your consultation, the higher the possibility of getting a discount on your immigration case. We give your case the priority that you do. So the sooner you pay for in full, the sooner it gets filed. We typically need several weeks once we've had all the documents, you've answered all our questions, and you've paid in full on your case. The more money you can bring to start it, the lower your payment plan will be, and the faster your case will be filed. How long does this process take? As of August 2020, it's taken up to 4 years for someone to obtain asylum status. In September 2019, there were over 300,000 asylum cases pending with USCIS, and that number has only grown. In April 2020, there were over 1 million open removal cases in immigration court. Most granted asylum cases have taken over 3 years to process. Once your application is received by USCIS, you will receive a notice of receipt. The date they received it will be very important, so hold on to it. You will need to review it as you determine when you can apply for employment authorization. Remember, as of August 25th, 2020, any application received must wait 365 days before applying for employment authorization. You will have an interview with USCIS. This may be scheduled in 6 months of filing, but it's not unusual to have to wait 2 or 3 years after your application is received. After your interview, you will receive notice if you are approved or denied. If you are approved, you can apply for your green card 1 year later. You can then apply to become a citizen after being a green card holder for 5 years. This is a difficult time for every immigrant to the U.S. It seems like this administration is making it harder and harder for those seeking for asylum. If you think you may qualify, please contact our office. We will work with you. If you don't qualify, we can help you determine your next best steps, including looking at the possibility of other legal status. We have often found relief for our clients when other attorneys said there was no hope. Thank you for watching. Please like and subscribe to see our other videos when they are released. Until next time, stay safe and well.